A subscriber of mine dropped a hint in a comment that I might like to look at a defendant that I had commented on previously. Oh my, this girl has continued to be a very bad pro se defendant. Let's talk about it. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. When Darrell Brooks represented himself as a pro se defendant in his criminal case, everyone thought that there were some pretty funny moments in that trial. He was hiding himself behind a bunch of boxes, for example. Generally speaking, though, there was really nothing funny about what Brooks did or the way he treated the judge in that case, and that judge had the patience of a saint. A good reason, perhaps, that I am not a judge. Sometimes the underlying events in these cases are truly tragic, and that's what we have in this case today. The underlying events were indeed terribly tragic, but they have produced something that is really kind of funny when you look at it. They're still being litigated in another forum, but what I found to be going on was really quite comical. I'm talking about this gal.
As I was being harassed in the media, I was working. And as I was being harassed by Metro Greenway, I was working. And here's what I uncovered regarding the murder of the four University of Idaho students. And I'm going to start from the beginning to the end. Before you watch this video, you don't have to believe anything I say. Everything that I'm saying and most of everything that happened to the students that night and before is evidenced in the app that Rebecca Schofield used to communicate with all of her collaborators. So if there is anybody who doesn't care about spiritual wisdom or does not understand spiritual wisdom, and you have the authority to do more, to get evidence, you can, if you have the legal authority to, subpoena Rebecca Schofield's electronics, subpoena these collaborative book apps, whatever you need to do to discover everything you need to know. She collaborated with all the people who helped her plan and execute the murders on that collaborative literature book app.
That's Ashley Gillard, who is a defendant in a defamation case. A professor in Idaho has sued her because she used what she called claircognizant skills to determine that the professor was indeed involved in the Moscow, Idaho crime for which Brian Koberger has now been charged. You all remember Brian Koberger, this guy. If you haven't been living in a cave in Afghanistan or been in a coma for the last 2 years, you recognize the name and that creepy look right up front. But apparently, Ms. Gilliard doesn't believe he is involved or believes that he is involved because the professor essentially hired him to do this. I'm not really sure what her allegations are. She couldn't put hell and O together to make a word, let alone a sentence. Her pleadings are just really not very well done. Her claim, at least as I understand it, was that the professor was somehow intimately involved with one of the victims and that because the victim rejected her, she wanted to make sure that she didn't get fired from the university because she'd had this inappropriate relationship or alleged to have that, and she used others to instigate a plan to do what it appears or is alleged that Brian Koberger actually did. Now, those of us who have an IQ above room temperature in degrees Celsius understand that after the arrest of Brian Koberger, there really wasn't a whole lot of doubt as to who committed that heinous crime. The FBI used forensic genetics to determine that Koberger would be the suspect. It was a masterful investigation, the kind of criminal investigation that the FBI used to do all the time and excel at. But our defendant here, Ashley, kept insisting on her claircognizant skills. She insisted really that they were simply infallible. She doubled down and claimed yet again that the professor was somehow to blame. I want to go on the record right now and say that, in my opinion, the judge got it absolutely right when he granted partial summary judgment on liability to the professor. Now, that's just my opinion, and my opinion doesn't matter, but that's what I think. The professor was actually nicer than a lot of people would have been in that situation. She used her lawyer to send not one, but two demand letters, or cease and desist letters, if you will, to tell Gillard not to continue posting this kind of tripe on TikTok. Again, a sane, well mannered, thoughtful individual at this point would have stopped, issued an apology in view of the criminal case that was pending, and hoped to heaven that the professor didn't do anything about it. But nope, she didn't. She doubled down. It truly is a masterclass in cognitive dissonance, or if you prefer, the Dunning-Kruger effect. A brief reminder, the Dunning-Kruger effect was named for a fellow who spread lemon juice all over his face, believing that it was something that would make him invisible because it worked as invisible ink, and then he robbed a bank without a mask or anything. He got 10 years in the federal pokey. Dunning and Kruger were the researchers who reported on the phenomenon of people who know just a little, but think they know a whole lot more than they really do. People like Darrell Brooks, people like Lori Valladero, people like Ashley Gillard. We don't need to look any further than the judge's order granting partial summary judgment and granting the plaintiff's request to amend her complaint to add punitive damages to figure out exactly what Ashley did wrong. And break out your legal tablet because the list is a long one. Let's look at that order. So, this is the memorandum and order on her amended motion for partial summary judgment and on her motion for leave to amend the complaint to add punitive damages. And this is what the judge writes. Pending are this motion for partial summary judgment and motion for leave to amend the complaint to add punitive damages. The court grants both motions as more particularly explained below. I want to point out why it is such a brilliant idea to only do partial summary judgment, because you definitely want to get damages from a jury and not from a judge. Judges tend to be a lot stingier with verdicts for things like defamation than they are for other things. So it's probably a good idea to get the jury to give you damages as opposed to the judge. So by asking for partial summary judgment, it's liability only. There's no need to prove liability. The only thing she has to prove is how badly this has harmed her. And I'm sure that her testimony will be very valuable there, maybe testimony of other people around her who can testify to how badly this affected her. And I'm sure that will drive up the numbers pretty high. Continuing on, he says the four university students, the incident involving them is what this is all about. Defendant Ashley Gillard posted over 100 sensational TikTok and later YouTube videos falsely claiming that plaintiff had an inappropriate relationship, and two, ordered the thing that happened to the four university students. It says plaintiff asserts two defamation claims against defendant. One is premised on the false statements regarding plaintiff's involvement with the actions themselves, and the other is premised upon the false statements regarding plaintiff's alleged romantic relationship with one of the students. It says here she didn't respond to the plaintiff's complaint, so she got a default. She moved to set aside the default. In April, the parties consented to the undersigned's jurisdiction because he's a magistrate, he's not an Article III judge. And thereafter, the court granted defendant's motion to set aside entry of default, denied plaintiff's motion for default judgment as moot, and ordered the defendant to respond to the complaint within 21 days. So 20 days later, she filed her answer, affirmative defenses, and counterclaims to the complaint. Within that pleading, she denied that she defamed the plaintiff because the accusations that she made in her TikTok videos were substantially true. So the defendant further maintained that her spiritual brain, how could you even write that? Intuition, spiritual practice, and investigative skills, which occurred behind a computer, to uncover the truth regarding the four University Idaho students, published her findings on TikTok social media platform. So in her answer, she's admitting that she didn't really have any basis to go on other than this intuition. Intuition's not admissible as evidence. The defendant also asserted 11 counterclaims against both plaintiff and her legal counsel. She suggested that the plaintiff did all the things involving the underlying crime and that she sought to evade suspicion by conspiring with her counsel to file a frivolous complaint with falsified factual allegations And then she claimed a violation of civil rights. It's just not cognizable. So on January 6th, plaintiff moved to dismiss, and the court granted the plaintiff's motion to dismiss, and the defendant requested the court to set aside its order because the court didn't have subject matter jurisdiction. And I mentioned earlier that that's just not going to go anywhere. And the court doesn't have personal jurisdiction, and it lacked judicial impartiality after it twice gave her an opportunity to do things that she should have done in a timely manner. The court denied the defendant's motion in its entirety on November 13th. In the interim, the plaintiff moved for partial summary judgment as to liability on each of her 2 defamation claims and the defendant's complete failure to respond to earlier served requests for admission. One of the things that's important with requests for admission is that if you don't answer them, if you don't respond in a timely manner and give them either admit or deny, they are considered admitted. They're not considered denied. They're considered admitted by default. Well, that's what happened. But the court allowed her to respond out of time. Again, the whole idea that he's biased against her is pretty ridiculous. So the court granted the defendant more time to respond. Defendant eventually responded to the request for admission, and the plaintiff filed the currently at issue amended motion for partial summary judgment. The plaintiff contends the defendant's admissions, the TikTok videos posted online, and the plaintiff's own declaration established beyond dispute that the defendant defamed her, and the plaintiff filed an at issue motion to to amend complaint to add punitive damages. She contends the defendant's repeated and ongoing defamatory statements about her without any factual support whatsoever are extreme, outrageous, and warrant a claim for punitive damages. So the court states what the legal standards are on a motion for summary judgment. If there's no triable issue of fact, in other words, if the facts are undisputed, the court can make the decision as a matter of law. And that's essentially what he points out. He says, but if you want to oppose that, then you have to put in facts from the record that establish that there's a triable issue of fact, and claircognizant abilities don't mount to a fact. And the court notes the court is not required to comb through the record to find some reason to deny a motion for summary judgment. In the end, the party opposing summary judgment must direct the court's attention to specific triable facts. And of course, there are no specific triable facts left at this point. And then he talks about to support an award for punitive damages, the claimant must prove by clear and convincing evidence oppressive, fraudulent, malicious, or outrageous conduct by the party against whom the claim for punitive damages is asserted. And it involves the intersection of 2 factors, a bad act and a bad state of mind. And we have those in spades here. In the analysis portion, he talks about the 2 defamation claims and that the plaintiff must prove the defendant communicated information concerning the plaintiff to others, and the information was defamatory, and the plaintiff was damaged because of the communication. But we're only going to have to deal with 2 of these because this is a case of defamation per se. When you accuse somebody of a criminal act or of something that is deviant behavior of, of a reproductive nature, deviant material of a reproductive nature, then you classify that as defamation per se, meaning there's no requirement that you prove actual monetary damages. It's just extreme and outrageous, and as a result of that, you're entitled to an award of damages. The plaintiff contends that for each of her 2 sets of defamation claims, the record establishes the first 2 liability-specific elements. And again, she only has to establish the first 2 liability-specific elements. Here it's undisputed the defendant communicated information concerning plaintiffs to others on her TikTok channel, and he goes through some of the examples of that. And then he says the defamatory statement is one that tends to harm a person's reputation, usually by subjecting the person to public contempt, disgrace, ridicule, or by adversely affecting the person's business. And he notes that the information communicated here about plaintiff within defendant's social media posts are unquestionably defamatory. It accuses plaintiff of having an inappropriate romantic affair with a student and then masterminding that student's the crime involving that student along with 3 other students to cover up the relationship. Trying to keep it clean here for YouTube. They don't like those words. And then he goes through all these things that she put on her TikTok channel where she laid out all of these alleged claims against the professor. Starts on November 25th and goes through all of the things that she said. Rebecca was the one who initiated the plan and hired JD, whoever that is. And then in December 1st, she posted another video about that she isn't remorseful. How she would know that, I have no idea. On December 2nd, she said that this gal was going to prison. On December 5th, she posted a TikTok video stating that she was a sugar mama to one of the victims of this particular crime. Can I just say how extreme and outrageous that is? You know, the family of the young lady who suffered as a result of that crime has been through an awful lot. And now to have this assertion that she is somehow involved in some illicit conduct with a professor and that she was using the professor as some kind of bank, that's just more extreme and outrageous than I can think of. She ought to be glad that the parents don't sue her for intentional affliction of emotional distress. And then in a later video on December 5th, she repeats the sugar mama stuff. On December 13th, she repeats the thing that she made no false statements and then makes a reference to planning a big wet one on her gluteus maximus. And so I don't have to listen to this demand letter because it's claiming I make false statements and I'm not making false statements. Doubling down after you get a cease and desist letter, again, is not smart. On February 8th, she posted another one. On June 8th, she posted another one based on the Nerd Report. October 14th of 2023, she posted a video criticizing plaintiff's counsel as well as the court. Okay, this judge has bent over backwards for her, and she's slapping him around, punching him in the nose, saying that, you know, he's not a good judge by repeatedly accusing plaintiff of an affair with a student and then ordering the crime against that student to cover up the affair. The defendant communicated information to others that was defamatory. Indeed, the statements are defamatory per se, meaning they're actionable without proof of special damages. Statements are per se defamatory if they impute to the plaintiff a criminal offense, which this does, or a matter incompatible with her trade, business, profession, or office, which a university professor having an inappropriate relationship with one of the students would be exactly that kind of thing, or serious reproductive misconduct. And again, it asserts that. If an alleged defamatory statement does not fall within one of these categories, a plaintiff must allege and prove some special harm from the communications. Critically, in response, defendant does not dispute that she communicated statements about plaintiff to others or that these statements, if false, are defamatory, but she says, look, they're true. I have consistently persisted that the statements I made are true. She just doubles down on this truth. Defendant therefore asserts that it's the plaintiff's burden to prove that her statements about plaintiff on her social media postings are false and that plaintiff has not satisfied this burden on summary judgment. But she has, clearly, and the court says that. Plaintiff disagrees that it's her burden to prove falsity, and the judge goes through a long thing about Idaho case law and truth or falsity and who has the burden and whether there are exceptions to that burden and what the growing trend is. He says the parties stake out their competing positions but don't grapple with this tension. Likewise, legal commentary comes up short in resolving the issue. So we come down here and he says he's going to throw up his hands. Ultimately, however, the court need not resolve the issue. Okay, so judge, why did you describe it? Why did you discuss it? But we'll leave that for another day. That is, even if if it is the plaintiff's burden to prove falsity, she's demonstrated there's no genuine issue of material fact that the defendant's statements about her are false. And then he goes through some of the stuff that establishes that. Moreover, in response to plaintiff's subpoena, the University of Idaho confirmed that it has no records of the students ever being enrolled in a class taught by plaintiff, or any investigation into plaintiff having an inappropriate relationship, or any investigation into plaintiff's involvement with the underlying crimes. So the court says, to be sure, Mr. Koberger was arrested and has been charged, and he points out that the docket contains the indictment against Mr. Koberger. He says this is powerful evidence at the summary judgment stage. It not only substantiates plaintiff's argument that defendant's statements about her are false, it also highlights the complete lack of any corroborating support for defendant's statements. So he goes on and says to be admissible, defendant's lay witness testimony concerning plaintiff's alleged conduct must be rationally based on defendant's perception and helpful to the fact finder. An opinion is rationally based on a witness's perception, where it's based on personal observation and recollection of concrete facts. Crucially, there is no legal support for the proposition that tarot card readings are grounded in any objective, verifiable facts from which defendant's testimony can ever be said to be rationally based. In other words, you're not being rational here, Ms. Gillard. As a result, defendant's psychic intuition without more cannot establish a genuine dispute of material fact. At bottom, the totality of the evidence reveals that there is no genuine dispute as to any material fact. Therefore, on the issue of liability only, the plaintiff's amended motion is granted. He then goes on to say that critically, defendant's social media postings continued even after she learned that the professor was not a suspect and that Koberger had been arrested. Plaintiff's motion for leave to amend the complaint is granted. Whether the defendant actually acted with such a harmful state of mind to support an award of punitive damages is a question for the jury and not the subject of this memorandum and order. So he went through all the facts, and he was pretty clear that this is going to be a case where the damages are going to have to come into the jury, and she didn't make her burden on summary judgment. So if you don't make your burden on summary judgment and you file a motion to reconsider, you have to explain why you didn't put that information in, and she didn't really do that. So we start with not answering the complaint, not answering discovery, having to ask for relief from default judgment, having to ask for additional time to respond to discovery, after the deadline had passed, by the way, which is something no attorney would have been allowed to do. The judge gave her a lot of room in this case. And then, to thank the judge, she punched him in the nose by calling him, albeit in a left-handed way, biased against her. She makes all of these mistakes, and then having made these mistakes, she decides she can correct it afterwards by challenging jurisdiction. Federal courts are courts of limited jurisdiction. They do not have unlimited jurisdiction. Gillard was right about that. But the problem for her is that the proper time to challenge that jurisdiction would have been at the beginning. At least with respect to personal jurisdiction, she has waived any claim that the court did not have personal jurisdiction over her. As to the subject matter jurisdiction of defamation in a diversity case isn't a problem here. First of all, the judge has an obligation to determine if there is subject matter jurisdiction at the outset. And if he believed there was a problem with jurisdiction, he would have raised that on his own motion, or what lawyers call sua sponte. But now she wants to challenge venue. But Idaho is the venue of the plaintiff's choice, and she'd have to show pretty compelling reasons to move it out of the state of Idaho. Because remember, she's already lost on the liability issue. The only thing that's going to be determined here is damages. And although she keeps asking the judge to reconsider that liability ruling, the reason she keeps asking him to reconsider it is because she believes she was telling the truth. Now, there is an important distinction here. You can absolutely believe that you are telling the truth and still be lying. When we say that truth is a complete defense in a defamation case, it isn't your truth, right? Your truth, that you believe that this is true. It is objectively whether it is true or false, and in this case, the assertions are pretty clearly false. That's what the judge determined. You can absolutely be cognitively dissonant about whether your beliefs in any way touch on reality. It's okay. It's pretty clear that she believes it, but she also, in order to do that, has to ignore all of the evidence compiled against Brian Koberger, and here's the really interesting part about that. She thinks that the evidence in that case will help her in her case. That's because much of the evidence in that case is still under seal. What she doesn't explain, and what she can't explain, is that the police have said that the professor had absolutely nothing to do with it. Now, certainly, if the professor was a co-conspirator in that crime, you can absolutely be sure the police would have pursued her as a co-conspirator. In one of her motions to set aside the partial summary judgment, she included this video.
This is for those of you talking about defamation lawsuits that don't apply to me. Long story short, the plaintiff, Rebecca Schofield, would have to provide convincing evidence of a defamatory statement's falsity in order to prove defamation. Rebecca Schofield does not have substantial evidence that she did not kill the 4 University of Idaho students. One, because they don't have a murderer. Two, she hasn't been investigated and substantially investigated and cleared by the Moscow Police Department or the FBI. She would need both of those things, a murderer, a different murderer, to be investigated thoroughly by Moscow Police Department or the FBI, and to get a statement from them saying that she isn't the killer, which they're not going to do that because they don't know who the killer is yet. Well, they haven't made it public yet. She does not have proof that what I'm saying is false. She does not have a case right now. She will never have the case because she's going to be caught. This is for those of you talking about defamation lawsuits that...
Now that you've seen it, you'd have to ask yourself, how in the world would this ever possibly help her with the judge? I know I'm confused. In Ray Stevens' song, The Blue Cyclone, which I've mentioned on here several times, there is a line by one of the wrestlers in that song that goes something to the effect of, well, it seems that some guys never learn. Well, apparently some gals never learn either. It looks like Ashley's trial is going to be set in August of 2025. I do not look for the court to stay the action on her motion, which is what she's asking it to do. And so I think the trial will probably go in August of 2025, and it will certainly be lit. And at some point, a jury is liable to come back with a whopping big number for defamation. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.